Okay, people, let's talk about reporting misconduct, okay? A lot of stuff here that ain't being done. Okay, diligence, who's communicating, fees, or any fees unreasonable because nobody's doing this. Conflicts of interest, you'll want to get into that. There's a lot of stuff. Let's go to the bottom. Respect the rights of third persons, responsibility of partners, managers, and supervisory lawyers. Remember, uh, lawyer working for you, he's literally depriving you of your right to effective assistance of counsel, not doing this. So, I mean, if you want due process, you want a fair trial. What you want first is effective assistance of counsel. You got to understand the mandatories of effective assistance of counsel. And that lawyer can't claim, hey, ignorance of the law. Ignorance of the law is no excuse for you, and they will use that against you in every and any court of law. So use that against them because they aren't ignorant of the law. They are just ignoring it. They're picking, choosing, cherry picking. No, they can't do that. They're supposed to use the rules, the codes, and every applicable law in the state or federal. Okay, so just taking orders is not an excuse. Ignorance of the law is not an excuse. Not a valid excuse for me, you, in any court of law. So use it against them. Okay, as well as the letter of the law. Any iteration devoid the letter of the law is misinformation. There's penalties for disinformation. There's penalties for lawyers and judges for disinformations. Fines include penalties are fines, removal of public service, and incarceration. Okay, and penalty, so you can't violate the letter of the law. That's illegal. Okay, there's penalties for violating the letter of the law. That's deprivation of rights. Okay, so there's a lot of things that you could say that if you go through my videos, you can throw at them, okay? And it all starts with this because all this is supposed to start at the very beginning, and it didn't. And that's misconduct. Okay, so anything you're going through now is nothing but legal harassment trying to get you to let this go. You know you're right, but you can't prove it, and that's because nobody's communicating with you, nobody's expediting litigation. See, look at where is it? Responsibility, subordinate lawyer, responsibility department, respect the third person, dealing with that. Oh, I hate when they do that, dealing with an unrepresented person. And it happens all the time. When people get arrested, usually when you ask for a lawyer, the person they bring is assistant state's attorney, and that's illegal. Truthful in statements to others. So they leave a lot of stuff out or they don't bring it up, so they'll say they didn't lie, but in the court of law, withholding facts, evidence, exculpatory evidence, that's illegal. So that's lying. That's not being truthful. Special responsibility as a prosecutor. Somebody said I mentioned that if you have exculpatory evidence, that you can go to the state's attorney's office and ask them to exonerate you because that's their job. It says right here, if you take the time to read the rules, professional conduct, it says right here, G, a prosecutor knows of new, credible, and material evidence creating a reasonable likelihood that the convicted defendant did not commit an offense of which the defendant was convicted. The prosecutor shall promptly disclose the evidence to the appropriate courts and authorities, and if the conviction was obtained in the prosecutor's jurisdiction. See, it doesn't have to be in their jurisdiction, you know. Probably disclose the evidence to appropriate court or authority, and if the conviction was obtained in the prosecutor's jurisdiction, promptly disclose that evidence to the defendant unless a court authorizes delay and undertake further reasonable investigation to make reasonable efforts to cause the investigation to determine whether the defendant was convicted of the offense that the defendant did not commit. When the prosecutor knows of clear and convincing evidence establishing the defendant, prosecutor's jurisdiction was convicted of an offense the defendant did not commit, the prosecutor shall seek to remedy the conviction. Okay, so you don't have to hire them. That's their job. Just don't go it alone. I got chased out of there a lot of times in the 80s and quite a few times in the 90s. Trying to bring up my constitutional rights in court nearly cost me my life. Okay, but see, it's the prosecutor's job. If you know and they know and you have the exculpatory evidence, and it's usually just evidence withheld in the very beginning. That's called partiality and decorum of the tribunal. That usually doesn't happen. Fairness of the opposing party and counsel, see? And it'll tell you the same thing. A lawyer shall not unlawfully obstruct another party's access to evidence or unlawfully alter, destroy, or conceal a document. See, so they're supposed to get, everybody's supposed to make sure you get discovery. Look up disclosure law, okay? So you didn't get discovery, which is illegal. Candid towards a tribunal, that means no lying, no holding back on anything, and that's what I'm going through right now. The lawyer isn't being candid with the tribunal, make a false statement, affect law to tribunal, or fail to correct a false statement. And he's failing to correct false statements. And I tried to do that. I had meritorious claims and contentions, and I tried to expedite that litigation by showing candid towards the tribunal. And in fairness to the opposing party, I was revealing exculpatory evidence to show that this case was frivolous litigation. See, so once you learn these terms, you can throw them around as easily as I do. And that pisses off a lot of people, lawyers and judges. Duties to former clients. Okay, well, anyways, none of this is being done, okay? Communication. The lawyer shall promptly inform the client of any decisions or circumstances with respect in which the client's informed consent. Okay, so remember I told you about inform yourself about informed consent. Diligence. I mean, come on, seriously, this ain't happening. A lawyer shall act with reasonable diligence and promptness in representing a client. That's not too hard to remember, folks, okay? And in the comments, this tells you how it's supposed to play out, okay? So, not doing it, doing all this would be competent, right? Okay? A lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and sorry, my vision is bad. Prepare reasonably necessary for representation. Legal skill and knowledge, and that would start with abiding by the rules of professional conduct, right? Enforcing, you're supposed to make sure, everybody's supposed to, in that courtroom, all lawyers and judges are supposed to make sure all this happens. So this is the mandatories of effective assistance of counsel in the Sixth Amendment of the United States Constitution. This is your constitutional rights, your civil rights. This is in the Bill of Rights. This is human rights. And as a United States citizen, this is your birthrights. This is your trust fund. This is part of your trust fund. If you look up the public trust fund, it'll tell you, you have to really get into it. It'll tell you, like, the court system is part of the public trust. Medical care, that's part of the public trust. They're supposed to make sure you're healthy and all that. Clean water, clean air, no pollute, the tolerance on pollution is way too high. There should be, actually, these days, there should be zero tolerance, okay? And that would require informed consent, and you didn't give that. So inform yourself about informed consent, and I'm trying to give you some, okay, so not doing any of this. Remember, they can't miss a beat, okay? And it's impossible, as I showed you, to just violate one rule. You violate one rule, you violate multiple rules. And when the rules are violated, it's only because the opposing party and the judge knowingly and willingly allowed your counsel to commit misconduct, okay? It is professional misconduct for a lawyer to attempt to violate the rules of professional conduct, knowingly assist or induce another to do so through the acts of another. Okay, so it's another lawyer or judge, they can't ask anybody to help them, which they always get everybody to help them, So that's the only reason they get away with not doing this is because the opposing party and the judge are just saying, go ahead, It's actually a game of give and trade depending on who the clients are. So reporting professional misconduct is mandatory, and it does. See, now listen carefully. Now you hold them to the letter of the law on this, okay? A lawyer who knows that another lawyer has committed a violation of Rule 8.4 or Rule 8.4c shall inform the appropriate professional authorities, which in this case it would be the ARDC or the Illinois Attorney Registration Disciplinary Commission and the Department of Justice for deprivation of rights. They don't mention that, and this is, you can also file for ethical violations as well. Okay, so just having any knowledge, a lawyer knowing that a judge has committed a violation of applicable rules or judicial conduct that raises substantial questions as to the judge's fitness for office shall inform the appropriate authorities. So people just having knowledge of misconduct, it's mandatory to report that misconduct. They don't have to be participating in it. They could be watching it on television. They could be watching it on YouTube. And I mean, it's crazy. You present it to them and they ignore it. The people that are actually supposed to be enforcing all these laws are the ones that are actually breaking all these laws. And they're not, you want accountability. Look up deprivation of rights. Look up a conspiracy against rights under the color of law. Look up deprivation of rights complaint form, a conspiracy against rights complaint form. And that'll take you to civil rights divisions, first and foremost to the Department of Justice, and they know what's going on and they're constantly watching it, and they won't do anything unless you file a complaint. Which is really crazy, people. So you don't actually have any constitutional rights. The only constitutional rights you have are the ones you earn. Okay, so I'm showing you how to earn them. And that's to know them. Open your eyes to open your mind. You read and you will succeed. And like I said, it always helps to take a copy of the Rules of Professional Conduct and the Code of Judicial Conduct with you. And what's won the day for me, that's what's won the day for me in many cases, taking a copy of the Rules of Professional Conduct, the Code of Judicial Conduct, and the complaint forms. So nowadays, all you got to do is look up the Rules of Professional Conduct like I did, okay? And let's see. Rules of Professional Conduct. Okay. Complaint form. It's on the ARDC. Okay, that's about as easy as filling out a job application. When I was doing this in the 80s, they didn't have this. I had to make my own. I'll show you those kind of cartoons. Okay? So first you want to start with a conspiracy against rights under the color of law. Deprivation, you're going to charge everybody for deprivation of rights because the judge violated the code of judicial conduct, the opposing party, the rule of professional conduct, your lawyer, the rule of professional conduct. That makes your lawyer ineffective assistance of counsel. And in layman's terms, defective, destructive assistance of counsel. They didn't do their job, okay? So before you start telling your story, you got to go over the rules and the codes. You're going to cite the judge, your attorney for ineffective assistance of counsel, the judge for judicial misconduct, and in a criminal case, the prosecutor for prosecutorial misconduct, you know. So you're going to have to go at three-prong. In a criminal case, you know, it's the three-prong, what I call, you know, it's the trident approach, you know. Three forks. You're going to use all three forks. You're going to go after the judge, the opposing party, and your attorney at the same time. And that's an easy win. And you don't need any evidence because nobody could prove they abided by the rule of professional conduct and the code of judicial conduct. Nobody can prove they were ignorant of these laws, and even if they can't. I already told you. Look it up. Ignorance of the law is no excuse. They say, well, I was just taking orders. That's not a valid excuse in a court of law either. They knowingly and willingly deprived you of your constitutional rights to due process, effective assistance of counsel, fair trial, failure to disclose when disclosure law clearly requires it. That violated the oath. That violated the rule of law. Look up penalties for violating the rule of law. Okay, so, you know, all you got to do is look up the rule of professional conduct and the rule of professional conduct complaint form. And that's where you start, okay? That's where you start. I can't guarantee they'll answer you. They answered me one time. And my complaint started with starting with the prosecutor. I started with failure to rule 3.8, and I just copy and paste it. Well, now I do, but I would just write that word for word because they didn't do any of that. They didn't do this. Did not comply. Did not comply. Did not comply. Did not comply. Okay, so that's what you're doing. You know, I mean, for every sentence in there, they did not comply. For every rule, did not comply. Every case is different, so you want to use the different rules and different codes in the courts. But remember, unequivocally, the common denominator in every court of law are the rules of professional conduct, and the code of judicial conduct is where you start, is effective assistance of counsel, and that was supposed to happen at the very beginning and didn't. So everybody, no matter what court of law you're in, has a case of deprivation of rights. Nobody being charged created a conspiracy against rights under the color of law. But start where it was supposed to start, at the very beginning. Start with that, the rules and the codes. None of that happened, so you're automatically, the presumption of innocence was null and void. The presumption of guilt prevailed, and that prevailed from the point of the litigation starting. You know, the preponderance of evidence, look that up. It's not there. It's non-existent. People can literally just make an accusation. They take your kids away. They put you in guardianship. What happened to their constitutional rights? What happened to their right to due process? Counsel. Not just effective assistance, counsel. People say, well, you know, who's going to... Even these kids, they're not just taking kids away from their parents, but they're taking a kid's life away from them without representation. Yet alone, you know, the parents are deprived of their right to effective assistance of counsel. You know, in fairness to the opposing party, it would be competent that they abide by the rules and the codes themselves. And same can be said for the judge. Okay, so nobody plays by the rules or the codes. They didn't do it from the very beginning. So the very beginning, you did not have effective assistance of counsel. Okay, and that's where the ball starts rolling. So if you watch my other videos, you'll find out a whole lot of more stuff you can add on to that. Remember, they'll use your ignorance of the law against you, and that is not a valid excuse in a court of law. So all I'm trying to do is deprive you of that ignorance and help you find your way. You know, when it comes to the law, I learned at a very young age, the only rights you have are those that you know. The only laws they'll enforce are the ones that you bring with you. And now you have that opportunity. Before I had to copy it out of books. You know, and but now, and you can do this electronically too. Okay, you can do this electronically. You know, I've been at this for a long time. It started with a dream in 1971. Carried on from there. To get our public servants to live up to what's been put on paper. People, you got to learn to start claiming your right to effective assistance of counsel, a fair trial, due process, a quick and speedy trial. You got to look up a quick and speedy trial. That never happens. You know, going beyond the limits of a quick and speedy trial is cause for the case to be dismissed with prejudice. I was just telling a young man in the state of Illinois that if you're out on bond, they got 120 days to get you to trial. Otherwise, the judge is forced to dismiss the case with prejudice, so they can't bring it up again because they knowingly and willingly violated the statute of limitations on a quick and speedy trial. And if you're locked up, they only have 90 days. But yet, there's people sitting in there a year, 2 years locked up, having that constitutional right of a quick and speedy trial violated simply because they don't know it. Somebody's holding their ignorance of the law against them. Man, talk about deprivation of rights. Talk about a conspiracy against rights under the color of law. But it happens in every court, so I'm just using criminal court as an example. You know, you have the same rights in civil court. When they try to take your kids, you have the same right. And remember, the presumption of innocence doesn't exist, so you'll have to prove yourself innocent from day one. And that, so if you go over the rules, that's candid towards the tribunal. There's a lot of things people won't bring up, you know, just to make you look guilty. And your lawyer's not going to bring it up. So you'll immediately have to cite your attorney for ineffective assistance of counsel, tell the judge to cite your attorney for ineffective assistance of counsel, tell the opposing party to cite your attorney for ineffective assistance of counsel for his failure to abide by, enforce the rules of professional conduct. And may I remind you, reporting misconduct is mandatory. Your failure to report is misconduct, creating a conspiracy against rights under the color of law. Him abiding by, enforcing, and living up to the rules of professional conduct is not just his constitutional duty. It's my constitutional right. And not doing so is not living up to the oath, and violating the oath alone is deprivation of rights, and him not being charged is a conspiracy against rights under the color of law. I can be a little uppity. It's called that in my younger days, uppity, about demanding my birthrights. as a United States citizen. Back then, you were highly judged by the content of your skin. Well, if you want to judge me now, you judge me by the content of my heart. And when you go over the law of the land, the United States Constitution, that is the content of my heart, which makes we the people who was meant to serve, protect the content of my, the Constitution, the content of my character, and we the people, the content of my heart, the many, many pieces of my heart. The Constitution, loyalty to the Constitution requires I put them before me. And I'm not even a public servant. I only took the Pledge of Allegiance, but still, I hold that near and dear ever since I first read it and knew it wasn't happening. And since then, I've been finding ways, doing whatever I can, finding whoever I can to help me in this endeavor. To make the dream a reality. In a nation of laws, all laws matter.